Morning, everybody. Lots of you will know me and the team, and you're going to hear from Laura and James a bit later. But for those that don't, I head the employment team at Actons, and we're running these webinars as close to monthly as we can. We have a little break over the summer, and we're really pleased that you can join us. We do a lot of activity on LinkedIn in terms of updates and connecting with clients and contacts. So do grab your smartphone and scan the QR code at the top right there to keep in touch. That would be great. Yeah, I'm pretty much there on LinkedIn daily. And yeah, in terms of Actons, we act for a whole range of different clients, through from startups and smaller SMEs through to bigger SMEs and some household names that you will have heard of. And yeah, we're really pleased to be with you today. The team, as I mentioned, you'll hear from, and do feel free to connect with them too. Just open the camera on your smartphone and give the QR code a scan. Laura in particular loves to connect on LinkedIn because she dislikes LinkedIn so much, but I like to give her a little mention specifically every one of these sessions that we do so that she's bombarded with invites, and that is definitely building her network on LinkedIn, so that's all good. So I'll give you a second or two there. In terms of the plan for today, we're going to obviously be talking about managing sickness absence, but we do cover a whole range of other areas of employment law, and we'd love to work with you if you are in need of legal support for anything, through from employment tribunals to managing sickness absence to employment contracts and handbooks, through to TUPE transfers and whatever else. And as you no doubt will be aware, the Employment Rights Bill is on its way and is nearly passed all the way through Parliament, and we are helping clients plan for what's coming there. So the UK employment law reform is a biggie at the minute, and there are things, although it's not law yet, there are things that employers can be thinking about in terms of planning for those changes. We wouldn't necessarily jump on a whole load of things that you should be changing just yet, but there are certainly things that you can be planning for. The other thing that I have the pleasure of doing is hosting something called the HRD Talks podcast, and I was very pleased to chat with Dr. Jo Burrell recently on the latest episode, who isn't actually an HRD, but she is doing an incredible amount of work supporting the HR profession through something that she calls supervision, and that's primarily focused at supporting HR with their well-being, mental health, and yeah, I guess really supporting the profession at what's quite a difficult time at the minute, where there's so much going on, and actually the perception of the profession is getting a bit of a bashing. Anyone who saw the Times article, I think last week, will have heard, you know, even the kind of existence of the profession is being questioned by many. So it's a really important time for the work that Joe's doing. So do check out that podcast episode. If you ask your smart speaker to play the HRD Talks, that will work, which my kids enjoy messing about with, or it'll be on any of the platforms that you can listen to podcasts. So you pick your favorite. I wanted to set the scene with a little sickness absence story that has kind of become a bit of folklore, probably because I tell the story too much. So apologies to anybody who knows this already, but it does set the scene in terms of the extreme end of what we see sometimes when it comes to managing sickness absence. And for anyone who watches a bit of Netflix, may be available elsewhere, you'll notice the guys from Suits, who are both lawyers, and it's a very tenuous link to the story, which was a lawyer who was underperforming at work and was being performance managed by his boss, and went off sick with stress and depression. And essentially, the manager left, and this guy remained on sick leave. The HR team changed over a period of time, and he went on to something called a permanent health insurance scheme. And the client then decided that they should deal with this issue, and called me many years ago and said, we have a long-term sickness absence issue. would you be able to help us with this? And it was the first job that we'd done together, and I was thinking, yes, absolutely, this is my speciality. This is great. We're going to, we're going to be able to help with this one. I said, how long has the person been off? And they said 19 years. And I said, you mean 19 months? And they said, no, 19 years. We forgot about him. So they then said, we'd like you to risk assess the case. And as you can imagine, there were a lot of zeros on the settlement figure that we ended up doing. If anyone has had an example that's longer than 19 years, do feel free to pop that in the chat, because I haven't yet found anybody that's the case. So yeah, I don't know whether anybody can beat that. But I'd love to hear if you can, or if you've come close. The sad thing about the story was that actually the individual hadn't told their family that they were off sick, and were getting up every day, putting on a suit and walking out the door. And unfortunately, it was a pretty sad story, but we did manage to get it resolved. And there was a semi-happy ending to that for the individual who was supported. So in terms of the plan for today, we're going to look at the context to all of this, and Laura's going to set the scene a little bit when it comes to that, so that we can then look at various other areas of managing absence. We thought it was useful to set the scene first of all. So Laura.
Thank you, Nick. Good morning, everyone. So yeah, as Nick was saying, I'm going to talk you through some of the context and the legal backdrop to what we're talking about today as part of this session. So one of the things that immediately jumps to mind is the cost to business of sickness absence. So we have, as you'll see on the screen, seen an increase in sickness absence following the pandemic. The 2024 figures start to show that we are coming down very, very slowly. So we're not talking massive coming down, it's about 0.3% of the overall absence that's come down last year, but we are still higher than we were pre-pandemic in the UK for absence. So in 2024, an estimated 148.9 million working days were lost due to sickness or injury. So that is quite a big figure. So when you're reading through that, you start to realise why sickness absence is such an important thing for us all to be thinking about and considering. One of the major contributions in the UK to why we're seeing such high rates of sickness absence is the rise in mental health related absence. So I had a quick look at some surveys, and there's the Labour Force survey, which has been done since about 1995 in the UK, looking at absence and the reasons for absence, and pretty much every statistic you could possibly think of surrounding sickness absence. So for the last decade, in 2014, the UK lost 14.8 million days due to mental health related absence, and in 2024 that had risen significantly to over 20 million. So that shows that is actually the fastest growing area of absence in the UK. The cost of absence is unknown. So the eager-eyed she would have seen that we put about £22 billion as the cost on the advertising for this this webinar. But the true figure is unknown, and there's a lot of different studies that say that it could be a lot more than that. So we are talking in the billions. There's other things to factor into that. So sometimes there's a hidden cost. So if somebody is sick but hasn't taken the time off, are you losing productivity from presenteeism, or they're unable to work at their full capacity? And obviously you've got the ones that might be more obvious. So when somebody is off, are you paying them an enhanced sick? Are you also then paying somebody else to cover that workload? Or on the other side, are you asking your existing staff to stretch and cover that, which again attracts different costs and thoughts. So there are some potential good costs to this. So there was a study by University of Nottingham, which obviously is down the road for those of us at Actons, that said that actually spending money on things like mental health training for line managers, although it's an outlay at the start, does reduce the overall cost, because it does actually, in their studies, reduce the amount of people that are off for mental health related reasons. So it's a bit of a weighing up and a balancing act for cost, but the overall thing is that actually days off in the UK really do start to stack up. So you'll see here that I've put together a little table. Those of you who are very good at maths like James have probably already added this up and said that this doesn't quite make the 148.9 million I just mentioned. You're right, it doesn't. I'm not a mathsy person. I don't want to do death by maths at 9:30 in the morning. So I've simplified it into regions for us because most people on this webinar, as we've established by the weather updates, are in the UK. So this is just an easy way of having a quick look and saying, well, actually, where do we sit on this table? So if you're in the northeast, you've got the least amount of time lost. If you're in the southeast, you've got the most, and here in the East Midlands, we're just edging second lowest. The study that I mentioned earlier, which is the labour force survey, can go into pretty much any detail you like. So if you are a statistics person, by all means, dig that out, have a look through. You can look at absence by age, sex, pre-known disabilities, location, much more. So if you ever want to benchmark your absence levels in your business compared to the national average, you could have a look at that. Or if you're like James and just like statistics, you might find it fun. So the legal risk, we said we'd talk you through the legal risk and the background to these. So one claim obviously is unfair dismissal. At the moment, we know that people need 2 years service to bring an unfair dismissal claim, but if you've joined us on any other webinars in the past year or so, you've probably heard us saying that's going to change in the not too distant future. So for now, we're talking about people that have got 2 years service that could potentially bring an unfair dismissal claim. In a claim for unfair dismissal, there has to be a fair reason for the dismissal to be able to substantiate and say, well, actually, that was the reason it was fair. So one of the potentially fair reasons in the UK, and I'm sure a lot of you know this, is capability. So ill health, performance-related reasons, and that is the one that's most likely to be related to what we're talking about today. I know James and Nick are going to talk through these things in much more detail, including how to identify potentially fair reasons and how to use medical advice and when, etc. So I will let them do that in turn. The other claim that we perhaps more commonly think of related to sickness absence is disability discrimination. So most of you will have heard the terms direct discrimination and indirect discrimination before, but just as a quick recap, direct discrimination is where there's less favourable treatment to an employee because of their disability. So for example, you interview somebody, they then say, actually, I've got this disability. You withdraw the job offer and give it to a non-disabled person. I know none of you are going to do that, but that's the quickest example of what a direct discrimination might look like in this. Indirect discrimination is where an employee is put at a disadvantage because of a provision, criteria, or practice, which is essentially a rule or a policy that you've got in place. So something that exists in your organisation that could indirectly lead to a disadvantage to a person with a disability. So, for example, you've got a bonus scheme that says that employees are only eligible if they've taken less than a certain amount of sickness, so 5 days or whatever in the past year. An employee who's got a disability was probably more likely to have had a number of days off or disability-related absences, etc., and therefore potentially more difficult for them to meet the bonus criteria. So that puts them potentially at a disadvantage, and that's an example of that. The two most common types of claim, as you'll see, are unfavourable treatment arising from a disability, and then reasonable adjustments. I know, again, that most of you will be familiar with the term reasonable adjustments, but what we're talking about here is anything that you can change in the workplace, so amending a rule, changing the environment, adapting the practice that you have to help reduce or, if possible, eliminate that disadvantage to somebody, an individual. So that could be things like remote working, creating a quiet space in the office, providing technology to assist somebody. There's a whole range of things that potentially are reasonable adjustments. I know the team might talk you through that in more detail in a few minutes, but it's just worth knowing that's what we're meaning when we're talking about this. And then certain types of discrimination claims can be justified, which always sounds a little bit odd when you say it out loud. But disability discrimination is one of those ones that can be justified, and I know the team are going to talk you through that, so I won't steal their thunder other than to say that even if an outcome can be justified from the process that actually led to that still has to be fair, so you still have to get the bit leading up to that fair and incorrect too. So sickness versus disability, as it says on the screen, not every sickness, absence or illness will be someone with a disability. So again, it kind of sounds a bit strange when we're saying it, but what we're talking about is actually a legal definition of of disability, not a medical one. So the statutory legal definition is on the screen for you. So a person has a disability if they A, have a physical or mental impairment, and B, the impairment has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So whether or not the employee meets that threshold of disability isn't necessarily something that you need to figure out when you're doing this. So you and we, if we're working with you, can look at what the employee is telling us about their condition, its daily impact, any medical evidence or occupational health report that's been gathered as part of a process, and we can make a suggestion on whether that's likely to meet the threshold of a disability or not. But in reality, the person that makes that decision is a judge and a tribunal if it gets to that. Day-to-day management then really comes down to if it's clearly not a disability, you don't need to treat it as such. So the routine sicknesses that we're all familiar with, and I'm sure we've all had to make that call at some point saying, actually, I've caught a sickness bug, I can't come in, I'm absolutely wiped out, I've got the latest thing that's going round, I'm full of cold, I need to be in bed with my LEMSIP. Those kind of things clearly aren't a disability. They're just everyday illnesses. But if there is a doubt, so someone phones in and says it's fatigue or pain, and that's potentially linked to a chronic illness, or it's a low mood that's potentially linked to a mental health concern, then if there's a doubt, treat it as though it is one. And that obviously might mean taking medical advice, taking occupational health. But again, I know that people will be talking through the steps that you might want to take with that in this session. And then statutory sick pay. Again, if you've joined us over the last year, you will probably be fed up of me saying things like this, but this is going to change fairly soon. So at the moment, SSP is only payable from day 4. As part of the changes to the Employment Rights Bill, that is planning on changing, so it will be payable from day 1. At the moment, employees have to be earning what is known as the lower earnings limit, which is currently £123 a week, to be eligible for that. Again, when the changes come in, that limit will be removed, so that all employees that are eligible for sick pay, regardless of how much they earn, are going to be getting statutory sick pay in the future. And for the people that are below that previous earnings limit that's gone, it's likely to be 80% of their earnings from 2026 onwards. Some people think that it's going to result in an increase in short-term sickness absence, where previously, like we say, people had to wait 4 days to get anything for their sickness absence. From April 2026, we're expecting that actually will be payable from day 1. Some businesses and industries will be hit harder by this than others. If you are already paying your employees enhanced sick pay or sick pay from day 1, then you might not see a massive change to this. But if you're not, and actually getting pay from day 1 is something that's new and novel for people, then you might see a change from this. It's hard to tell really what the actual overall impact on this will be, so it'll be interesting to see what happens when it comes into force, but it's just something to be mindful of, that actually this is something that might change at the point that this comes in. So I'm going to hand over to the team now to take you through in more detail.
Thanks, Laura. So I'm going to focus first of all on the first bullet point, everyone, the short-term persistent absence. I'll then pass over to Nick to talk about long-term absence, and then we will come over some tricky issues on various topics at the end, which hopefully will bring things together. So moving on to short-term absence, often persistent, otherwise it tends to be less of a problem. And I've suggested here, Nick might beg to differ in his section, but it can be trickier than long-term absence to manage short-term absence. Why do I say that? Well, a few reasons really. One of them is that it can often be ignored until it becomes a bit of a problem. In some ways, it can sort of creep up on an employer. Somebody's taking a few days off here and there. It's not really an issue, but then across the course of a year, they've taken quite a lot of days off, and it can become quite disruptive. Often more so than longer term absence, because it's more unpredictable and it's harder to get cover if people are off for short amounts of time frequently, rather than if someone's off for a chunk of time, perhaps due to an illness, an arrangement can be made and planned for their return. The other is just the very nature of short-term absence. It tends to go in peaks and troughs. So it might be harder to understand the why behind it. Is there an underlying cause? Is there not? And sometimes there will be, and sometimes there won't. So how you react to a short-term absence of employer has to be quite flexible, because the circumstances are going to be different on many different occasions. So hopefully this morning we're going to explore a few techniques you can use to try and respond appropriately depending on what the issues are. Just as a point of confusion, I want to avoid any confusion. What I'm talking about this morning is short-term persistent absence. So what I'm not talking about are things that can be confused as absence issues, but in my view are disciplinary matters, which are people just not coming into work. That's an authorized absence, and that's a disciplinary matter. Or people failing to comply with absence reporting processes. There's a difference between not being sick and not following the rules. And so if people aren't phoning in or emailing in or doing whatever it is they're required by your absence procedure, that's not a short-term absence issue. That's a disciplinary matter. I mean, if they're off, then there may also be a short-term absence issue there, but you don't want to be conflating the two things. And what's also not a short-term absence issue is people taking various forms of statutory leave or time off for medical appointments. There's different laws that are engaged there as to why people may or may not be allowed to take those, and they're separate issues that I'm not going to be talking about this morning. I suspect there's also a slightly grey area which you might come across, and a good example of that might be the employee who tends to be off on a Friday or a Monday, and you might be a bit suspicious as to why that is, and how do they have a health condition that means they're generally fine Tuesday through Thursday and not Monday and Friday. It might be a situation where you might want to investigate, but it's going to be quite difficult to produce any evidence that they're genuinely, what's the old-fashioned term, swinging the lead, shall we say, on Mondays and Fridays. And so often you might just want to treat that as a short-term absence, because it will be a lot more difficult for you to be challenged if you just take as face value that they're absent for a genuine reason in the absence of anything other than sort of suspicion. So we're going to assume for my section that we're either genuine absences or ones we're assuming to be genuine absences, even if we might be a bit suspicious. Absence procedures, they're a very handy tool when managing short-term persistent absence. A lot of organisations don't have a specific absence process, and that's fine. You can deal with short-term absence via a capability procedure, but it is probably more difficult for managers because and you've probably, some of you have come across these, some of you might not have done, detailed, sometimes they're called attendance procedures. They're very common in large employers, or I've seen them quite a lot in manufacturing or in the public sector, whereby there's a set structure and targets are set usually by reference to either days absent or occasions of absence, or sometimes in relation to sort of mathematical metrics that Laura would love, things like the Bradford factor, where you multiply absences by occasions of absence. And then the basic sort of theme that most of these procedures have is there are sort of trigger points. However, they're doing it, whether it's days, occasions, Bradford factor, or a combination. Once an absence point is triggered, it often triggers a meeting and could lead to a warning or an improvement notice. And the aim of these procedures, policies, is, and should be anyway, to actually improve attendance, to snuff out the problem. But if it doesn't work, there is usually a mechanism for it escalating ultimately to a dismissal if an acceptable level of attendance can't be maintained. Something I'm going to say a few times in these slides, I'll try not to labour the point too much, is that if you are going to get to the point of dismissing someone for short-term absence, and similarly for long-term absence when Nick speaks, you do need to be mindful of the ACAS code of practice. It would apply to this type of dismissal. So all the basic things you'd know from doing disciplinaries or capability processes in a performance context apply here equally. So the right to be accompanied, letters warning what might happen at meetings, rights to appeal against sanctions, that all applies in this context too, and should feature in any management of absence, whether that's following your procedures or just doing it more loosely via a capability process. And finally, the last bullet point, engage employees on their attendance and issues of their attendance. It's an important one, but also a really quite an easy win for employers. So a classic example of that is just the value that can be gained from return to work meetings. So even if someone's off for just a day or so, sitting down with them, finding out why they were off, seeing what they say, comparing that perhaps to a sick note, or often in this type of absence, there won't be a sick note because they won't be off long enough, because it will just be a day here or there, but what's written in the self-certification forms, and just keeping a record, even if it is just the self-certification forms and notes of return to work meetings, because you never know when down the line this might escalate, or there might be a pattern or a problem that you're analysing. And that'll also help you spot underlying health conditions, which I'll come to in a second. So as I say, engaging with the employer is going to help you identify the reasons for the short-term absence. And there's lots of sources that I've looked at as to what that is. One of the reasons we're always looking for things like underlying health conditions and reasons is because, as Laura's hinted, disability discrimination can become a live issue in short-term persistent absence. And employment tribunals have a concept that's called by lawyers, it's not the greatest phrase, constructive knowledge. It's where employers are deemed to know things that they might claim not to know. And that arises in situations where employment tribunals think that if the employer had taken reasonable steps, they would have found out things. And reasonable steps isn't as complicated as it sounds. It's things like asking the employee, looking at the information available, and then drawing logical conclusions like, oh, look, these all seem to be a series of connected illnesses. Do we need medical information to tell us whether there's an underlying condition? Should we refer to occupational health, for example? And if the evidence suggests that you should, then the tribunal might think that you reasonably should have done, and then you might be deemed to have known things that were in a report that you didn't obtain or didn't obtain until later. So don't sort of close your eyes to the evidence in front of you. Do explore whether there is an underlying health condition. The final bullet point, medical information, is it necessary? Well, interestingly, in the leading case on the fairness for dismissal for short-term absence, quite an old case, an EAT case, Linux against cereal packaging, the judgment said that it's not necessary to have medical evidence in every case, although it did say that you should be considering whether there's an underlying health condition. So I suspect that it'd be more of an exception to the rule where you didn't have medical information, even if you were obtaining it just to rule out your assumption that there was no underlying problem. For example, because the series of absences you had seemed to be for completely random, unconnected reasons. It might be there will be cases where that it isn't necessary because you've critically analysed the information and you've deduced that toothache is unlikely to be linked to a broken foot, for example, or similarly diverse ailments. But a lot of the time it'll be worth doing just to rule it out. And I've hinted at the next slide in that analysis there. When will it be fair to dismiss an employee for short-term absence issues, persistent absence or excessive short-term absence? And if you are dismissing, what reason are you relying on that's fair? A lot of people jump to the conclusion, quite understandably really, that a short-term absence dismissal is a capability dismissal. They're not capable of coming in. But sometimes that can be problematic in situations where you're getting to the point of dismissal when the employee is actually in work and they're telling you there in the meeting there's nothing wrong with them. And that's led to analysis over the years through the courts as to what the reason is genuinely in these short-term persistent absence reasons. And then in the leading case, Wilson and the Post Office, the Court of Appeal gave us a nice summary, which I'm going to read out because I think it's easy to understand. They said that the failure to meet attendance targets or to comply with an attendance procedure would come under the wonderful broad catch-all that we all know and love, some other substantial reason. That reason being the failure to meet the attendance targets or to comply with the attendance procedure. So it's usually in this scenario an SOSR dismissal. And I actually did argue that very point based on that case. I thought it was only a few years ago, but I looked up the date of the judgment and it's slightly concerning. It was on the 1st and 2nd of June 2017 in the Birmingham Employment Tribunal. And the judge asked me what fair reason I was relying on behalf of my client. And I said some of the substantial reason based on Wilson and the Post Office. And he awarded me a bonus point which I was very pleased about, because I think there's only one judge in the employment tribunals who awards bonus points. And they're completely meaningless. For those on the call who think this is totally bizarre, the first time he mentioned it, I was taken aback. But there we are. If you've been in the Birmingham Employment Tribunal before this judge, you'll know all about bonus points. If not, you'll think it's completely bizarre, because it doesn't happen anywhere else in the country or with any other judges. But that's only half the battle, establishing the potentially fair reason, and it's the easy half. The next thing you have to worry about is it actually fair to dismiss the employee in the circumstances you're faced with for their short-term persistent absence? And the thing you'll want to know is, well, how do you work that out in advance before you get to the employment tribunal? Well, luckily, in the case I mentioned earlier, Linux against cereal packaging, they gave us some clues as to when such a dismissal will be reasonable. And the clues from the case are the 3 bullet points on the slide. So what you need to be doing before you pull the trigger and dismiss someone for that reason is to fairly review the pattern of absence and the reasons for them, which is just pulling together all the things I mentioned before, holding meetings with the employee to find out why they're off, seeking their input, analysing that, looking at the sick notes, and potentially exploring the underlying condition, if there is one, via getting medical information or ruling it out. The second, giving appropriate warnings to the required improvements. Now, if you've got an attendance procedure, then usually that will have sort of guided you on the train tracks to do that. You'll have said, you've hit this trigger, you've got this warning, you need to stay under this level, otherwise you'll get to the next trigger, the review period is X. And then the second half of that bullet point is the ACAS code point, indicate when dismissal is being contemplated. If you're ever going through a procedure of this type, or even a normal disciplinary, and the employee is coming to a meeting not knowing that they could be dismissed, then that is going to be a problem of fairness. Finally, consider whether there is adequate improvement in attendance, and this can be the trickiest one. Again, if you have a rigid procedure, then it can perhaps be easier, but you could have a difficult situation where you're faced with someone who is improving quite significantly, but perhaps they're still not quite meeting the thresholds because it might be quite tight. And you would have to consider whether or not you should rigidly apply or whether there should be some leeway. And that will be a judgment call in each case for you to decide. Now that all seemed relatively straightforward, and in the short-term absence context, unfair dismissal is substantially more straightforward than disability discrimination. So if you're managing short-term absence and you can happily rule out there being an underlying condition or a disability, then life is a lot easier. But often it doesn't work that way, and there is the potential for a disability to be in play. And this is where I get to do the bit that Laura was flagging and talk about the different parts of disability discrimination that apply in this context. So the first one I'm going to look at is the claim of failure to make reasonable adjustments, because the starting point for a reasonable adjustments claim is where an employer applies a so-called provision, criterion, or practice. Now, is a good thing is we've got an easy example for this type of scenario is the attendance policy I was just talking about that requires people to meet certain targets. That is one of those provision, criterions, or practices, or PCPs. And so the question becomes, does applying that put a disabled employee at a substantial disadvantage when you compare them to someone who's not disabled? A lot of the time the answer to that will be yes. A disabled worker is probably more likely to be off sick more than a non-disabled worker. So let's assume that it does put them at disadvantage. So that then triggers the duty on you as the employer to take such steps as are reasonable to alleviate that disadvantage. And that's where the points on the slide come in. So how could we do that to alleviate the disadvantage? Should we just be completely discounting disability-related absence? Or should we be avoiding rigidly applying the attendance triggers? Or what should we do? And it won't always be clear-cut, but in an absence policy scenario, usually the logical reasonable adjustment would be adjusting the triggers. How much can be quite a tricky question, and that's where medical information and expert information can really help you. So you can be asking occupational health things like, what level of absence would you expect to be likely from someone with this person's disability? And that can really guide you. Just discounting disability of absence altogether is often not going to be a reasonable adjustment, because it's going to render the policy probably quite useless, in that if the majority of their absence is caused by the disability, then just discounting it entirely isn't going to be of any particular use. You may as well not go through the process of this policy. So it's likely that making adjustments that are more nuanced than sweeping will be reasonable. But the beauty of reasonable adjustments is you need to consider it on a case-by-case basis, looking at things like effectiveness, cost, and impact on the workforce as a whole, as to whether an adjustment or not is reasonable. The second claim that arises often, the same facts can lead to the two claims being brought together but argued in different ways, is the claim Laura talked about, discrimination arising from disability. So again, sickness absence is a great context to look at that, because it's quite straightforward. So the disability is whatever it is. If the absence is caused by the disability, then the disability-related absence is the so-called something arising. And then the unfavorable treatment that you as the employer might subject them to might be, for example, giving them a warning because they've triggered the absence triggers. So that will be, as Laura said, discrimination, unless, big unless, that unfavorable treatment was justified. And the last bullet point says, when can it be justified? Well, justified is another one of those difficult concepts to apply in practice. It's where you're doing something that is a proportionate means of achieving a legitimate aim. And more legal jargon, I'm afraid. But if we take the legal jargon and make it simple, what's the legitimate aim? It's ensuring a decent level of attendance in line with your policies. So that's quite easy to work out. But then what's proportionate? And you have to consider, again, a bit like the reasonable adjustments analysis, something that's proportionate is going to have to factor in that the disabled worker is more likely to have absence. And so applying the regime in the same way you would to a non-disabled employee is likely to be not proportionate, and some tolerance should be afforded. How do you do that? Again, my suggestion would be to seek medical information as to what reasonable levels of attendance would be, and potentially adjust the triggers accordingly, or give further chance to improve, or make amends to ensure that you're proportionately applying this and not falling foul of discrimination. So that sums up the short-term absence piece. Nick is now going to talk about the long-term absence.
Thank you, James. So I should have said at the beginning, if anybody does have questions, we've had one in the chat already, feel free to pop those in as we go. Anything on James's session or mine as we go. We will have some time, hopefully at the end, for some of those too. But yeah, feel free. So long-term absence. So James has obviously covered what we're describing as short-term intermittent absence. So a day here, a day there on a repeated basis. And I guess I would make the case for it being as equally as tricky to manage longer term absence. But James is quite right that actually the short term intermittent days off can be difficult to address, particularly if they're not being tracked well. But let's focus in on longer term absence. So I guess the focus of this part of the session is very much about risk assessing these issues, and then really using medical evidence well to help manage the situation. So it's less about the legal claims, although clearly it's very much about ensuring that you're minimizing the risk of those, but hopefully some practical tips in terms of managing these situations. One thing that I'll touch on fairly regularly is occupational health advice, and where absence moves into this sort of longer term scenario, as James alluded to with the shorter term stuff, it's pretty essential that you get good medical advice, and we'll look at the different types. What I would say is that historically our view on the quality of occupational health advice that employers were getting wasn't great, but I think there is a push from employers, to say, look, we need help with this. And certainly there are a few providers now who are, I think, improving the quality of the advice they're giving. We're certainly getting very good feedback about a company called Smart Clinics, who a number of our clients have been using recently. And therefore, if you're, unfortunate enough to need occupational health support in this kind of scenario, or it's a regular thing that you need because you've got lots of employees, and it's just part of doing business as an employer, it's definitely worth checking those guys out. So a little plug for them. In terms of how we approach this part of the session, in fact, Sarah's jumped in and said recommending Smart Clinics. There you go. Really, part of the way that I look at this is we're looking to support our employees and look after them and fulfill our duty of care to them. But we're also, and this is I guess the tension that HR people, live with a lot of the time. We're supporting the individuals, but we're also looking to support the business in achieving what the business is there to achieve. And I suppose those two things butt up against each other a little bit in this area, and navigating a way through with the benefit of medical advice is really what we're talking about. The other thing that we do a lot of the time with clients, and we try and help clients do this without us, I suppose, at the outset of these kind of situations, is risk assess the situation. So a bit like the 19-year situation, that was an obvious one to risk assess. It was going to be very difficult and it was going to be very risky and costly. Having some initial thoughts in terms of risk assessing a situation is really helpful in terms of how you then navigate the absence. So how long has the person been off? What is the condition? How serious do we think it is? What medical advice do we already have? So it might be that we've had some sick notes. Hopefully we will, given it's longer term sickness absence. Have we already looked at adjustments? What can we do to help the person return to work and improve their absence levels? Have we dealt with other similar situations? Can we be consistent in the way that we're dealing with these things? And then also, I think from a kind of legal risk perspective, then looking at what kind of claims the person might be able to bring, and how much the person earns is there on the slide, because that is the risk factor in terms of unfair dismissal and disability discrimination claims, in terms of the financial risk that you might be facing should the person have a successful claim. There is something called injury to feelings, which again you may be familiar with, that's not linked to loss of earnings, but a big part of this would be, particularly if we end up dismissing the individual, that they will be looking at a loss of earnings claim of some description, and that's the risk for you as the employer. So when we're approaching managing the longer term sickness absence, I try and break this down into the sort of three strands that we need to look at. One of those is consultation with the employee. And again, it sounds very grand, but it's essentially talking to the employee about what's going on, what their absence is, how they're doing, what they might need to help them be better in terms of returning to work, and talking to them about the medical advice that they have or that we're getting through occupational health, for example. Then there's the strand, the second strand there, which is medical advice itself, and we'll talk more about that as we go through the session. But also then that business need that we're talking about. So this is often the bit that I think employers miss, although it's probably most important to them very often, in terms of the cost of the absence that is being experienced by the employer. So that might be having to pay sick pay, it might be having to employ or engage somebody else to cover the work. It might be the impact on the rest of the team who are having to pick up the slack because the person's off sick. It might be particularly busy periods within the year, seasonal work, for example, that puts an extra strain on the workforce as a result of this person being off sick for as long as they have been. And weaving that into everything that we're doing in terms of managing the absence is appropriate, but I think is often missed. And tribunals, because they look at how things are in the workplace and in businesses and organizations, they will take account of the impact that absence has on the employer too, as well as just focusing on what we did with the employee. So it is important, I think, to talk to the employee about that, build it into your audit trail when dealing with these issues. So medical advice, again, as I said, historically, I think poor occupational health advice hasn't helped employers, and things like, the employee will be off for the foreseeable future is not a helpful, bit of advice, because nobody knows how long that is. And actually, when we're managing these issues, getting as much certainty as we can, and it's difficult, but getting as much certainty as we can is helpful to employers when managing these issues. Now, it's not just occupational health advice that we might have. It may be that the individual has a letter from their GP with a bit more detail. It might be that they've been seeing a consultant and they've given a view on things. It will, be important to take all of this into account, but certainly as the employer, you are entitled to rely on occupational health advice that you have commissioned, and in fact, prefer that advice in many circumstances over and above other medical advice that you've been given. The other thing that we sometimes see, although it's pretty rare, is with particularly complex conditions, and I mean really very unique, medical conditions. It's important to ensure that the person that you're getting the advice from is suitably qualified, and it may be that occupational health will say, actually, you do need an independent medical expert here, somebody who's a specialist in this field. I don't know, potentially a particular brain condition or something, neuroscience related, that kind of thing. It might be necessary. The difficulty with that is that they can be very expensive to commission reports like that, but it might be in very rare circumstances that's necessary. I think Stephen's popped a question in about finding that GPs are reluctant to advise on conditions and adjustments and refer back to OH. Yes, and I think my thinking with GPs is personally, when it comes to advising clients, I wouldn't bother getting advice from GPs for similar reasons to what you have experienced, Stephen. Sometimes they're not prepared to give much more information. I think also there's issues around the fact that they have direct care for the individual and therefore are likely to give a view, often, if I'm being honest, sympathetic to the individual and not necessarily taking into account the employer's side of things. They're also, unlike occupational health, they're not experts, unless they're an OHGP of some kind. They're not experts in terms of how that condition will interact with the workplace that the person is working in. So yeah, it's fairly limited that I would be recommending to clients that they go and get medical advice from the GP. Although it's free or usually lower cost, it tends to have less value in my opinion. So occupational health advice certainly is very, very important, which is why finding a good provider that you're happy with is so important. Employee consent, so asking the individual to go to occupational health in the right way, and ensuring that it's all done from a data protection perspective properly, it is obviously important, given the sensitive nature of medical conditions and medical records and the like. A lot of occupational health providers are now onto that and are helping employers through that process. So we're not going to major on that today, but it's certainly worth being aware of. And again, we would help clients with that if occupational health weren't supporting in that way too, but it's definitely worth keeping an eye on. And then in terms of getting good medical advice, I think definitely finding the right occupational health provider for you is important. But then a lot of the work that we do with clients in these situations is also maximizing the chances that you're going to get good reports from the occupational health provider, something that's helpful to you in terms of managing the situation. And our experience there is asking the right questions is more likely to increase the chances that you get the right answers. So being clever with the questions and asking the right stuff is important, but also including enough information. So often, whether it's a standard occupational health referral form or a letter that you write, what we see is that there isn't enough information provided by employers for the occupational health practitioner to really understand what's going on, what's been done, and how the workplace actually operates. So including things like job descriptions, a history of what's happened, adjustments that you've already considered, and as I talked about earlier, the impact that this situation is having on the business as well as on the employee is really important in terms of increasing the chances that you'll get good medical advice back from occupational health. And therefore, it's important to really focus on that rather than just saying we've got an employee who's sick, and this is what they're telling us is wrong, and that being that, building into that audit trail plenty of information about what you have done and what impact it's having on your business is really important too. I think Maisie's asked the question about if someone's refusing to go to occupational health. It's a really good question, and it sometimes does happen. My advice there generally is ask and explain why it's important. If the person refuses, engage with them as to why they're refusing, and explain that you think it's really important that you have medical advice to understand the situation with them and their medical condition and the reasons that they're absent. I would usually also emphasize the fact that you as the employer are not a medical expert. And in fact, even though the individual is experiencing whatever illness it is, they are also not a medical expert. That's why we have medical experts, because we're not all, even though we're going through things, qualified to know how we are and how best we get better. So I would be explaining to them that you feel it's really important that you have that medical advice in order to fulfill your duty of care to them as their employer, and ask again. And if they continue to refuse, I think you get to a point where you effectively have to say to them, we're really sorry. We think it's reasonable that we ask you for this so that we can support you properly. But if you continue to refuse to attend occupational health, then we will have to take decisions about your absence and potentially even your employment in the absence of medical advice, which we think would be helpful for us to do that well. And I think the key really is, from a risk perspective, ensuring that you have a good audit trail showing that you've been through those steps, in order that you can explain why you didn't have medical advice and that it was very much because the individual refused to engage with that. So hopefully that's helpful, Maisie. Medical records, again, I think it's less common these days for occupational health to review full sets of medical records and request those from GPs, although in the past we have had that. The key for me is that in the referral, you're saying, please let us know if you need any further information. And I usually add in, including any medical records, so that you're pushing that on to occupational health in terms of them ensuring and kind of almost confirming to you that the report they're producing is, appropriate in the circumstances, and that they're happy that their professional obligations are fulfilled in that way. So asking the right questions, I talked about that. Obviously, the background we've talked about in terms of what we build into the referral. Asking the right questions is really important. And I think, obviously, things like what condition is the person suffering with? Are there any adjustments that can be made? Can they fulfill, their duties as set out in the job description, and so on, are really important. There may be other specific things that you want to emphasize linked to the business need. And I alluded to this earlier in terms of seasonal working, and retail, I guess, is a good one where it's super busy at Christmas and in the January sales. And that's a neat thing to link your question to, in terms of asking whether the person will be back in time to support the workforce and support the employer by that point. And that's generally how I try and help clients bring these longer term absences to an end, by saying we need everybody back for this busy period or this project or whatever it is. The team's been struggling because they've had to pick up this work, and there's, the people are starting to get ill themselves, or whatever it might be, linking it to a business need with a time scale. So it might be that it's October time, let's say, we're almost there, and you're already planning for Christmas because you get super busy at that point. And you might say to occupational health, can you say with certainty that this person will be back and fully functioning within the next 2 months? And the idea of that is to give an end point. So rather than having this foreseeable future response, the person will be off for the foreseeable future, we start to manage that timeline, and we start to get an occupational health and medical review on whether that's likely or not. And that then allows us to link that back to the business need and start to put an end point on this. The other thing that probably slightly controversially I talk about quite regularly with clients is removing reference to whether the person is disabled under the Equality Act or not. Now, nearly every referral form that I've ever seen has this question on it. And I think, as Laura talked about at the outset, that question relates to a legal definition in the Equality Act. It's the sort of thing that only really an employment judge can decide at the point you're in a tribunal hearing, debating and arguing as to whether the person is disabled or not. It's not something that we can definitely confirm to you, and it's certainly not something that a medical person who's not legally trained can confirm for you. And therefore, my personal view is it's not something you should worry about asking. That's not to say that you don't need to consider as part of your own risk assessment whether the person might meet the definition and therefore be disabled, and as a result, need certain action. But I just don't think it's a question that's helpful. There's also a number of reasons why it's unhelpful. One of those is actually, in some ways, it's a waste, because as James talked about, I think, or even Laura at the beginning, if we have somebody who's off sick that has a long-term absence and therefore is probably quite unwell, we are likely to be considering adjustments to try and help facilitate them back to work. And whether it's strictly speaking a disability or not, we're going to need to do that anyway. So reasonable adjustments will come into play. We're going to be trying to support them back into the workplace. The other reason for not having it in a report that will then form part of a tribunal claim is that if actually we have a medical person that decides they are going to answer that question, and often they don't, and increasingly we're seeing medics saying that's a legal question definition, we're not going to respond to that. But if they do, we then at tribunal, should we, for example, be deciding that we're going to dispute the fact that the person meets that legal definition, that we're disabled under the Equality Act, we have a report that we commissioned which suggests that they are, which immediately puts us on the back foot at the point you come to us and say, please, can you help us defend this tribunal claim? Because it might be that there was scope to argue that the person wasn't disabled, but our own medical report says that they are, despite the fact that it's not a medical decision, it's a legal decision. Now, we have had cases where we've still managed to dispute disability successfully, even in the face of having a medical report which said that, but clearly it's unhelpful, I think, in that situation. And as long as we are taking our responsibilities to that individual seriously in terms of managing their ill health, I don't think it's that helpful a question. But anyway, that's long enough on that. You can see that I feel quite passionately about that particular issue. In terms of next steps, where we've got our medical advice, we need to look at the report and read it well. And I would say, if you're unhappy with the report that you've received, I would really, really encourage you to go back to your occupational health provider and say, we don't actually think this is helpful because you've not answered the question, or the answer to the question is a bit woolly and we don't have enough certainty. Can you please have a look again and finesse that? Or you seem to have missed some issues, or whatever it might be. I think it's really important that you don't accept poor quality responses on that. If you're paying for a service, that makes sense in lots of areas of life. And I think just because occupational health are the professionals that have come back with something like that, it doesn't mean that you shouldn't question their advice and understand it properly. Once you're happy with the advice that you've got, that it's accurate, you might not be happy with it in terms of what it says, but that it's accurate and it answers the questions. Talking to the employees, that consultation part again, in terms of this is what the report has said, what do you think of it, this is what it's suggesting we should do, how do we implement that for you, are really important. And lots of that will revolve around the reasonable adjustments piece that James talked about earlier as part of his session. We're then looking at, is a return likely? So it might be that we've asked that kind of, can you say that they'll be back type question and they've said no, and that actually all the other stuff that we have in terms of our ducks in a row mean that it's not likely they're coming back, and we're going to move to a kind of dismissal process as part of managing that absence. Or it might be that actually it's much more positive and they're saying, yes, we think they will be back, things are improving, and then it's more about how do we help facilitate and support that moving forward. The other thing just to keep in mind, because they're sometimes missed, but again, I think they're increasingly rare these days, are things like ill health retirement. So certain pensions setups would have an ill health retirement option as part of that. Again, I was seconded to a large bank many years ago and helped them with the criteria for getting ill health retirement issues through via the pension trustees, but also the permanent health insurance scheme. So that's the scheme that people can go onto and get a percentage of their salary paid by an insurer, essentially, that supports them through that absence. There are some employers that still run those schemes. They are rare, partly because it makes it very difficult to ever dismiss somebody who's on long-term sickness absence if they're on that scheme. But clearly, for people who are really genuinely very unwell, it's a great thing to be able to support them in those circumstances. The example of the 19 years that I gave, the individual did go onto that and was receiving 75% of his salary for 19 years with an inflationary increase. So yeah, it had a fair amount of money over that period of time via that scheme. So in terms of summarizing that section, medical advice, as you'll have picked up, is incredibly important, and I think is the bedrock really of how we're managing this. Consultation, so remembering to talk to the employee about the situation, and I think that's the thing that sometimes is missed too. It's okay to contact your employees who are on long-term sick. Clearly harassing them daily is not a good idea, but regular touch points and contact is appropriate, and that is something that's important to do too. Keeping in mind that business need, so linking everything back to the fact that we need them in work and why. Audit trail, you'll hear us regularly talk about that and the importance of it, creating the right audit trail and keeping records of all the steps that have taken place. Then following that fair procedure is obviously clearly very important, and alternatives like other roles or ill health retirement or PHI schemes, shouldn't be forgotten too. So if you didn't think that was tricky enough, we're just going to highlight to finish some of the key areas where we see extra complications, I suppose, in these areas. And James is going to kick us off with a few of those, and I'll be back shortly.
Thanks, Nick. And then I see there's one question in the chat on your bit, Nick, that you can cover, but the most recent question actually links neatly to what we're going to do right now, which is poor performance, and particularly where that performance could be linked to illness or sickness absence, but probably more just illness in general. And this is slightly sort of linked, but not so related to managing absence as such. But the reason we've included it is because a lot of the principles and ideas we've talked about and what you might do in the absence context also apply when you're managing poor performance, where there might be linked reasons. So with that in mind, the second bullet point is investigate, don't jump to conclusions. It might be that you think that the employee is not performing because they're ill or because there's an underlying health condition, or it might be that the employee says that that's the reason. But how do you actually find out? Well, go through the process Nick just said. If you're unsure, seek medical input and make informed choices without jumping conclusions. But also, as I alluded to earlier, if it seems quite likely, then the employment tribunal might have expected you to explore further by doing things like involving occupational health to get that expert opinion. The disability discrimination claims that I alluded to earlier also apply in the poor performance context. So instead of the absence being the thing that arises from the disability, it could be the poor performance. So you need to assess whether it is, and if it is, and then you're taking steps to manage that performance. Can you justify those, or do you need to be allowing more tolerance to the employee before you perhaps give them warnings or reduce targets or change timescales. And similarly, I talked about reasonable adjustments. I'm going to make the same point again, but in a different context, in explaining where it can go wrong in the performance context. Is that the issue I see with employers and employees getting into a tangle with reasonable adjustments is what they tend to do is jump to the end. So you've probably all had a situation where an employee comes to you and says, I need the following reasonable adjustment. And they're therefore in a sweeping statement, they've analysed what the PCP is, what the substantial advantage is, what the adjustment is, and they've self-declared the reasonableness of it. And sometimes the employer's reaction can be very defensive to that, which is, well, we're not doing that. And then they then double down on the mistake by falling into the same trap by saying, well, we won't do what you've asked for, but we'll do this. And then you get a bit of a standoff where the employee wants X and the employer wants Y, and nobody's really thought it through correctly. So what you need to do when you're faced with the employee who says, I want X, is take a step back and work out what it is that's wrong with them, what the disability is, what impact that has, what the disadvantage is. Then you need to work out what adjustments could you make to alleviate that disadvantage. Does the thing they've suggested actually alleviate the disadvantage? And then assess whether the thing they've asked for is reasonable. So how much does it cost? What impact would it have on everybody else if you implemented it? To what extent does it solve the problem? If it's just a minor little bit of help that doesn't really solve the problem, it's just what I would say is nice to have, then is it really reasonable? And I think that the classic reasonable adjustment of the last 3 years is an employee declaring, I need to work from home permanently as a reasonable adjustment. And often if you work through the analysis I just went through, you don't get to the conclusion that it is a reasonable adjustment for them to work from home permanently. It's just something that they would like. It's an aspirational thing, or it might be because they want to drop off the dog or go for walks at lunchtime, or pick up the kids from school, or it means they'll get home from work sooner, which perhaps has absolutely nothing to do with whatever it is that's the disability in play. That's not to say that working from home wouldn't be a reasonable adjustment. In some cases, it absolutely would potentially. But you do need to work through your analysis to work out why you're deciding not to do something if you're not to do something. And the danger is just agreeing to reasonable adjustments that the employee presents to you without much critical thought is you might then get into a difficult situation about removing it, because whilst if it wasn't a reasonable adjustment and you took it away, the employee might struggle to succeed on a claim for failure to make reasonable adjustments. You might be in other problems in terms of grievances and fairness. If someone's saying, well, why are you now saying I can't do this when I've been doing it fine for X amount of time and there's been no problems? And it could be, for example, that somebody else has asked for it and you don't want everyone doing it. So by not engaging with the reasonable adjustments regime and critically thinking through whether to grant things that employees are requesting or not, or whether to do something else, you can create problems down the road. So always worth working out why you're doing something before doing it, and having a logical thought process, because that will help you with other cases and also just consistency of approach across the workforce. The next tricky issue, which again I suspect you've all come across in various contexts, is issues with sickness, absence, or illness when there is a live disciplinary or grievance process, or both, in play. And the classic one, probably in the disciplinary context, is where the employee who has had no prior illness or nothing of note is all of a sudden too ill to attend the disciplinary hearing, often when they've been suspended. And in a lot of occasions, obviously, that people do get ill, it might be true. A lot of occasions it's because they're desperately worried that they're going to be dismissed, for example, and they're just trying to kick the can down the road. So it won't always be necessary or reasonable to postpone. You might want to postpone on one occasion, but sometimes it's not going to be helpful to anyone to continue to postpone, because the reason that the employee is sick is because of the impending disciplinary, and the only way to resolve the issue is to actually hold the disciplinary. Sometimes you might want to get occupational health advice on fitness to attend meetings. I made a key distinction there. If someone is off sick, unable to attend work, that's slightly different from whether they're able to attend a disciplinary meeting, because if they're able to attend the disciplinary meeting, it might, as I said, resolve the issue of the disciplinary matter hanging over them and actually bring things forward. So sometimes you might want to frame your questions, as Nick alluded to earlier, as to the context of what you're seeking the information about. Is it could be two separate questions. Are they fit to attend work? If not, are they fit to attend meetings? Or are they fit to attend meetings with adjustments? And you could consider other ways of getting through the disciplinary or grievance process, whether that's doing it at a neutral venue, doing it by video like we're doing now, or telephone call, or just in writing, or looking at ways to move things forward. And the other is running concurrent processes. I just want to briefly cover. Sometimes there's a concern that if you've got absence issues or you've got sickness issues or grievances, that you can only do one thing at a time, and often employees or I see it quite frequently when trade unions try and always filibuster and try and have as many different processes going on at once to say, well, you can't do this one until you've done that one. That's not necessarily the case, and that the ACAS Code of Practice specifically envisages when you might want to run a grievance process and a disciplinary process at the same time, whether that's because the two things are linked or because the two things are not linked and there's no reason to delay. There will be cases where it's appropriate to pause one whilst you complete the other, but you shouldn't. There's no one solution for all scenarios. So don't fall foul of feeling that it must be one way or the other. Consider what's reasonable in the specific circumstances, and do what is appropriate to keep things moving on at least one of the strands, and perhaps more. And finally, again, this tricky issues area is a bit sort of a random. Nick's got a few more on a similar theme to, well, not similar theme to alcohol, but a unique issue. So alcohol can often come up in the sickness concept. The law does say explicitly that alcohol dependency in and of itself doesn't fall within the definition of disability. I've always assumed that was a public policy consideration when they drafted the Act, but that's one of those careful things to know, because things that could arise as a consequence of alcoholism could well be disabilities. So if somebody develops a liver disease, for example, then that could well meet the definition of a disability if it hits all the criteria, and it's irrelevant that might have arisen because of excess alcohol consumption, or that it didn't. It doesn't matter either way. But in the alcohol context, when you're managing issues, whether that's conduct issues or absence issues, it is a potential underlying cause. And some of the principles we talked about earlier as to whether you should be taking that into consideration or making adjustments, you'll have to look at. Often it's useful, and a lot of organisations do have a policy specifically related to alcohol, and usually these days that's sort of joined in with substance misuse or drugs or similar, because they're going to have very similar issues. So you do need to be careful as to whether or not you're appropriately warning or following your own policies, because often in extreme examples, turning up for work under the influence of alcohol is listed as a gross misconduct scenario, and so it can be easy for a manager to just jump straight to the conclusion, well, that must be the conclusion, it's in the list, therefore I will dismiss. I'm not saying it's not something you could dismiss for, but as with a lot of these things, it's important to work through your thought process as to how you're getting there. Are we following the policy? Is this an underlying cause? Would it be reasonable to perhaps provide them with the opportunity to try and solve the problem before we jump straight to dismissal or warnings? How much is the employee willing to engage with that type of discussion about solutions, admit to the problem? So these are all factors. So this shouldn't be taken as sort of a blanket advice to do things one way or the other, but just to consider all the factors before you make decisions, and be confident in why you're doing whatever you decide to do. And the last three tricky issues Nick is going to cover.
Thanks, James. So just the last few, just to touch on areas where we see additional complication, I guess, for employers in terms of managing these kind of issues. And yeah, then we're aiming to finish by 11, and we're looking pretty good on that. So neurodiversity, increasingly common that there is a neurodiversity element to sickness absence issues, often combined with other issues like relationship breakdowns within the workplace, or underperformance, or whatever it might be. And we're seeing more and more neurodiversity cited as part of the mix of those kind of situations. And I guess I think would suggest treating those kind of situations like any other kind of absence or any other kind of condition, and getting good medical advice to help you as the employer manage that situation well. And again, increasingly we're seeing occupational health providers releasing new assessment tools and services that are specifically designed, for this purpose. So I'm not necessarily planning to go into loads of detail as to how we manage that, because again, it will be very fact specific based on the situation. But it's almost flagging a trend that we're seeing increasingly within our kind of our work, that this is increasingly an element of that, and I think employers need to be mindful of it and avoid sort of tripping themselves up by not factoring in, this into the situation. So if your occupational health provider does provide a particular support service in that way, then that's helpful. And obviously, again, there are a lot of people who will help employers proactively ahead of there being issues, manage and support neurodiverse colleagues well too. And obviously with lots of this stuff, it's less of our focus for the session, but if we can avoid these issues in the first place, then that is obviously good. Menopause is the other topic that we're seeing an increased focus on generally, but also when it comes to these kinds of issues. And I think regardless of whether you think this is right or not, the way that menopause has been protected in employment tribunal claims, and therefore in the kind of the workplace, has been by people pursuing claims for either age, sex, or disability. And that's the link here, really, is that we're seeing an increase in claims in the employment tribunal relating to menopause. And in fact, I think the stats last quarter showed something like a 32% increase in claims involving menopause. But essentially, the most common claim that seems to progress and have some success is a disability discrimination claim based on the symptoms of menopause. And the Rooney case that we've included on the slide there is one example of that, where the Employment Appeals Tribunal decided that menopause in that case was a disability. And I think that's the key factor here is, as you might imagine, as with any other condition, and I use that carefully in this context, but the tribunals look at it in that way, and they decide whether the symptoms that the person is experiencing meet the definition within the Equality Act for disability protection. So it will be very much decided on a case-by-case basis. And again, I don't think employers should get too hung up on that definition and whether it's met, because in reality, a bit like I was talking about earlier, if you have somebody that is saying I'm experiencing symptoms and they're impacting my ability to work, then supporting them and trying to alleviate that, as Laura talked about in the introduction, is clearly a good idea anyway, because you want people in work and functioning well. And therefore, if you're doing that, the chances are you will have ticked those reasonable adjustment boxes should there end up being some sort of issue and a disability claim on that basis. So again, we may well do a session on this in more detail in the future, but it was to flag that as another trend that we're seeing more focus on now. Clearly, it's been an issue for some time, but it's certainly very much in focus at the minute. Cancer is another topic that we just included just to finish up on these sort of trickier issues. Again, automatically a disability under the Equality Act. There will be a requirement to make reasonable adjustments, consider sick pay, time off, all that kind of thing. I think increasingly we're seeing employers that have a policy on this to try and ensure consistency. I was working with a client recently who were very unfortunate to have a number of employees who'd all been diagnosed with cancer at a very similar time, some of it very serious. And I think it was incredibly difficult for those individuals, obviously, but also for the employer to manage well in very difficult circumstances. And I think consistency was the key that they were looking for in terms of how different managers managed those situations for their teams. And they did introduce, I think, policy to try and help with that, but also not forgetting the effect on co-workers in those situations where they're working alongside colleagues with cancer, or dealing with the fact that somebody is absent as a result. And I think providing appropriate support in those areas is really important when it comes to that. Many of the same principles that we've talked about apply when it comes to cancer situations too. So one or two more slides just in terms of managing the risk of all of this. We've talked very clearly about capability and absence policies, and James quite rightly pointed out that it's possible to manage these things without those, but particularly for managers and particularly for consistency across an organization, it's actually really helpful to have those policies in place. It may be that you want to include certain things in your employment contract, things like a requirement for people to go to medical referrals, occupational health referrals, if you ask them to, although we've talked in the chat about the difficulties around that if someone just point blank refuses. Things around sick pay, and Laura flagged the SSP changes that might have an impact on what you want to pay in terms of company sick pay or employer sick pay. The importance of good procedures and GDPR compliant processes is obviously really important too. So as part of that, what we've actually launched for this webinar is something called a sickness absence audit. So we get asked to do this on occasion with clients, but I think increasingly we're seeing the importance of this area both from a legal risk and a PR risk perspective, and employers taking it much seriously, I think partly because of the cost of absence. So actually HR teams, I think, are going to their internal stakeholders and saying, we can help improve your absence levels, and that will have a knock-on impact in terms of productivity, efficiency, and so on, and reduce the cost of sick pay and that kind of thing. And I think employers, that's a big deal for most employers at the minute, and therefore getting a grip on this area is really important. So as part of the audit, we look at sickness absence procedures, and if you don't have those policies, we can help with those. But are we legally compliant? Are they consistently applied and clearly communicated at the minute? Can we work on improving those processes to help deal with absence more quickly? We'll look at any other associated documents like employment contracts and other policies that might be linked to that, and also manager capability. So we're doing a lot of training at the minute in terms of helping managers better manage absence and a number of other issues, because it's increasingly important, I think, particularly with a lot of the stuff that's coming in the Employment Rights Bill, for employers to be, for managers to be suitably sort of qualified and equipped to deal with those kinds of issues. So the audit then will produce a report which highlights the kind of legal risks and gaps and steps for improving those and plugging those gaps, as it were. Best practice guides for helping with some of that stuff, so return to work meetings, for example, and things like that actually really do help manage absence on the ground, as it were, and really giving an insight into how we can help reduce absence and therefore reduce cost too. So I think Matt or Iveta will pop a link in the chat to a web page that has more detail on that absence audit, and also I think a fancy QR code where you can book an appointment to chat more with me about how we might help with that audit, if that's something that you're interested in. Obviously, if you have an absence case that's particularly tricky at the minute and you need advice on that as well, we'd be happy to help. But this QR code will allow you to book an appointment in my diary to talk about the absence audit, so that we can look at whether we can help you with that and kind of look at it holistically in terms of managing all of these issues based on the experience that we have of working with clients to try and reduce absence in these areas. So hopefully that's helpful. Do click through to the web page and book something in if that's of interest. And I think we have 3 or 4 minutes. We've had lots of questions as we've gone, and I know James, as I've been talking, has been furiously replying to those questions. If you do have any other questions, please do pop them in the chat now. We've got a couple of minutes just to pick those up. If not, and it's a more detailed advice that you need, obviously you have our details to make contact either through LinkedIn or our details are all on the website, and we'll be really happy to help where we can. Anything in the chat, James, that you haven't got to? It looks like you've done a pretty comprehensive job.
Some good questions, some tricky questions, and things that are hard to advise on without further context. There's one about, would it be okay to make sick pay subject to compliance with conditions? Yes, broadly. It's quite common to see sick pay being subject to compliance with absence reporting obligations, and similarly, if someone's not complying with a reasonable request to go to occupational health, and that's a term of the contract, then you could withhold company sick pay. But as the questioner has quite rightly pointed out, if they meet all the criteria for getting statutory sick pay, then you'd have to pay that, because that's under a different regime. Contractual sick pay due under the contract, statutory sick pay due if you meet the legislation test. You can't sort of contract out of statutory sick pay.
Yeah. Couple of thank yous and some nice feedback in the chat too. Andrew has asked what will happen with ACAS and the Employment Tribunal overall in terms of workload with the ERB coming. Absolutely, we do have a view, and we're already seeing the tribunal creaking under the weight of lots and lots of claims. And ACAS, I think increasingly we're getting feedback from clients that ACAS are also overwhelmed and not able to kind of conciliate in the way that clients might be hoping. So we think that's likely to get worse on the basis that certain provisions within the ERB, so unfair dismissal rights, being made day one, and things like longer to bring employment tribunal claims will mean there will be more tribunal claims. And there are a number of other changes that are likely to result in that too. So tricky. There's going to be more of it for sure. And longer wait times, I think, on hearings, which are already into 27, maybe even 28 at the minute. So that's 11 o'clock. Do get in touch if you have any other queries. The absence audit link is there too. I'd be happy to chat through how we can help with that. Stephen's asking about any further sessions coming up. We don't have any in the diary yet, but the next thing that we do after this call is plan the next session. And as I say, we're trying to get them in monthly, probably October, early November will be the next one. And part of the reason for flagging LinkedIn is that's where we tend to push that out. If you're on our mailing list, you'll also get it there. If not, again, LinkedIn is a good place to contact us to get on the mailing list. So do drop us a line if you're not on the mailing list and would like to be, for further invites to this kind of thing. And also we have a monthly newsletter which we'd be happy to send out to you as well if that is of interest. So thank you for all the lovely feedback. It's been great to see everybody. Hopefully that was a useful session. Do connect with us on LinkedIn, final plug for that, and we'll see you all next time.